All right, we're live here in the House Judiciary Committee this Wednesday morning, January 31st. And this morning we're going to be taking testimony on H780. I have to say there's going to be a lot of pressure on me chairing this meeting because we have two past chairs of the Judiciary Committee and a vice chair here as well. And I'm sure that I will get input on my behavior from them afterwards. But scorecards. Okay.
If you don't give them your opinions on it, I will.
Yeah, this is a lot of pressure. This is a lot of pressure. But
we believe in you.
well, see, thank you very much. I feel supported. I feel supported. So we're going to start with Judge Amy Davenport on H780. And just by way of introduction, so you don't have to spend a lot of time on, there's at least one change that almost everybody has said they don't like it. So happy for you to weigh in, but you don't have to spend a lot of time on eliminating the resident requirement. So other than that, everything else is still kind of on the table and we're looking at, but that one.
Well, you've got a solid no. A solid no.
Yeah.
And the designate.
Well, right. And there's also language that, but it's still up in the open as well. The executive director of racial equity should also say or designee. And we're looking at different ways to try to bring in some diversity as far as the setting up of the judicial nominating board.
Right.
And this isn't necessarily the answer. We've kicked around some other ideas and would love your ideas on that. And any other things relating to the court and judges and such, but I'll turn it over to you. Thank you very much for being here.
Oh, you're welcome. And thank you for asking me. Just for the record, I'm Amy Davenport. I am currently a retired Superior Court judge. I was appointed to the bench in 1990. I basically served all over the state on the bench until 2005, when the Supreme Court appointed me to become what was then called the administrative judge, what's now called the chief judge. And actually that was something I asked them to do after I left, because everybody gets confused when you call yourself, especially if you go out of Vermont, call yourself an administrative judge. They say, oh, you do Social Security cases? No, I don't do Social Security cases. So the chief judge just seemed like a more appropriate title. So I'm going to speak today just, about my own experience, primarily as the chief judge, in terms of new judges who came on the bench during the 10 years that I was the chief judge, what was required. And I really can only speak to the period that I was a judge. But let me just start by saying, I think the nominating board has a very difficult task in front of them. I'm not sure that when you get appointed to the nominating board, you really realize how challenging this task is to try to figure out whether the person in front of you will be well qualified to become a Superior Court judge in Vermont. It's challenging, of course, because you have to weigh their expertise, their experience, and I would say importantly, not only their legal experience, although it's not actually written into the bill, but their life experience as well can make a difference in terms of how well they're able to perform their job. Their judicial temperament, and of course we know how important judicial temperament is. You cannot, somebody who tends to lose their cool easily is like in the wrong place if you put them on the bench. Their ability to be able to explain complex matters to people who represent themselves, complex legal matters. I mean, I think as attorneys, we often get into a mode of, talking to other attorneys and they all understand what I'm talking about. But when you're talking to people who are not attorneys and who are representing themselves, and for them, whatever the case is, it's just really probably the most important thing in their life when they are appearing in front of you. You have to explain to them why they can't introduce hearsay. And you have to do it in a way that they will understand. And that is not easy. So there just a lot goes into finding the right, the well-qualified candidate that goes beyond just, legal knowledge, and what their legal experience has been. I would also highlight their willingness to learn. They're going to have to learn a lot. Most lawyers, as I think this committee discussed when the Chief Justice was here talking about the DEI Commission, most lawyers specialize. In Vermont, judges do not specialize. The Superior Court judges do not specialize. They will be expected, and it's quite necessary, in fact, because we are a small rural state, but they will be expected to know how to do a civil case, a criminal case, and a family case. And so whatever specialization knowledge they have as they come onto the bench, they're going to have to expand. And they have to be really willing to do the work to learn. And they have to be willing to work hard, because one of my experiences as the chief judge or the administrative judge, when new judges came on the bench, was if they came from, and several of them did, if they came from a law firm that had secretaries, they expected that there would be a secretary to type their 25-page, 30-page decision. And there is no secretary that types judicial decisions. Judges are expected to type with a word processor, to use a word processor to write their decisions. And that's a learning curve. I mean, if you have no skills at all, I have a husband who's a complete Luddite. And he has tried to learn, but he came from a law firm where he had a secretary who did everything, and did all the typing for him, and the drafts and redrafts and redrafts and redrafts. And, he just has never been able to learn how to use a word processor. So, that's that in and of itself. We had a couple of judges who literally out of their own pocket hired somebody once they got on the bench, and were so frustrated with trying to write their decisions, they hired somebody to work for them part-time to type for them so they could dictate and somebody could type for them, because they weren't. Now, I think that's less of a problem today, because I think most of the generation that's now being considered to be judges have grown up in an era where they know how to, you can't go to college now, not know how to use it, or law school. So I think that's less of a problem, but it just kind of exemplifies how judges get appointed. And this was always such a surprise to me. When I applied to become a judge, actually before I filed my application, I went to a judge, some of you may remember Shireen Fisher, who was really wonderful. At that point, we had a Superior Court and a District Court. She was a District Court judge, but she was a wonderful judge. Later went on to be a member of the War Crimes Tribunal in Sarajevo. And I went to lunch with her, and I spent 2 hours with her asking her about what the job was like and trying to figure out whether I could really do this job. I was amazed when I became the chief judge, how many new judges had never talked to anybody about what the workload is. They just didn't know, and they were shocked. They were shocked that they would have to spend weekends writing findings. They were shocked that they would have, these time pressures to get decisions out. It was, and it surprised me that they knew as little as they did. So I think it takes a lot of different skills to be good at this job, but very importantly, it does take a willingness to learn. So turning to the bill itself, I don't have, with respect to the change for putting on the nominating committee, the executive director of racial equity, back when I became a judge, I was the second woman Superior Court woman to be appointed to the Superior Court. And then there were two women who were in the district court. So when I was appointed, there were basically four of us. I remember going to my first judge meeting, and there were it was me and three other women and a sea of male faces. That's changed. Thankfully, that has changed. And I think I don't know what the percentages are now, but I think the percentages are pretty good gender-wise. But definitely, we need more persons of color. As Justice Waple says, she is the only person of color at this point on who's now a justice, but was a judge. And we need more diversity. I will give some thought to other ways you might get there, but I really think that has to that's something that needs to change. I think having I'm on page 3 of the bill as it was introduced, the change that requires the 3/4 majority vote. I really like that change. Well, for one thing, you've made it 12 people, so you can't just have a majority anymore because otherwise you get ties. But I think that the nominating committee should be really convinced, and 3/4 of them should be convinced that this person is the right person to be on the list that gets sent to the governor.
Is it majority now?
It's majority now, right. So you can there are 11 members, you can get 6-5 decisions. And yes.
Hi,
Hi, how are you?
good. How are you?
Very well, thanks.
So, I know a little bit about this board.
Because you're on it. Okay.
The only thing that I want to add to that is I kind of look at it a little bit maybe differently. Where we have a job to do, we go and we interview the people, right? And then how they come to us, and then we make that decision. And then ultimately, it's always up to the governor to make that final decision. And we hear quite frequently that, we want more names, we want more names, we want more names. And so we try to do our due diligence to get the names that are up there. And sometimes that's very difficult. It's just like people of color and the other stuff. I mean, a lot of us are out there.
But that's your job to send the most qualified candidates. And I would say, regardless of whether somebody is saying we need more names, we did our job.
We did add well qualified, right?
Yes,
Yeah.
it does say well qualified. Yes. And I think the qualifications are, as I've said, are critical. And I do know that in the past, when we were trying to get more women on the bench back in and this would be in the 90s and the early 2000s, there would always be complaints when the list went to the governor and there were, maybe one woman was on the list and, 5 men, people always looked at that. I think less so now, because we have a much more balanced. So I think once you get to some balance with diversity, it becomes less of a pressing problem, but it is, I think we'll get there. But it just is a willingness, I guess, to look at different candidates, even ones that are from diverse backgrounds, but always applying that well-qualified criteria.
Judge from Northfield retired, sent me a note one time, and it's very good reading. He said, "So you want to be a judge?" And I don't know if you've ever seen it, if Bob's ever seen it, but it is fascinating about what you go through to be a judge. It is just, it's
a lot of pressure and a lot of, being able to keep your cool under circumstances that can be quite tough.
yes.
So Ella has a question as well.
Yes, sorry.
No problem. So on that piece around both the well-qualified and the 3/4 majority, we heard from the Office of Racial Equity that those are historically things that, like bumping up the threshold in both ways further limits historically marginalized people who have had historically less opportunity to have the kinds of experiences. So like I hear you saying you
Yeah.
want people to feel like this person is really well qualified, and that the more people on the committee feel that way, the better. And yet that narrows the pool. And then like, for me, it's less about how many names and it's more about like, it's going to take a long time for the committee to be as diverse as we want the judge, just
Yeah.
to make that change over time. How do we do that if we're further limiting through the vote and the
Well, I
how
think,
well qualified?
I think it really depends on how you define well qualified. And in the past, at least my experience, again, when I was chief judge, was well qualified was defined. There certainly is an emphasis on the qualifications, on how many jury trials have you done? How many contested hearings? How well do you know the rules of evidence? How, what was, did you clerk for a judge after you went to law school? That's been kind of how a lot of the bar anyway defines what well qualified means. If that had been the criteria when I applied to be a judge, I would not be a judge. I would never have become a judge. I had only been admitted for 8 years. Back then, it was not 10 years, it was 5 years. So I managed to slip in, but certainly compared to other people who applied for the judgeship that I applied for, 8 years was probably the lowest amount of legal experience. I had a lot of my legal experience had been sitting where Chairman Lalonde is sitting, because I was a member of the legislature for 6 of those 8 years. And so I spent a lot of time in this building and not in courthouses. And frankly, when Governor Cunin appointed me, there was a lot of criticism from the bar that I had not done enough jury trials. Was not a litigator. I was not somebody who was in court every day. What I can tell you is that when I did do, shortly after I became a judge, I did do a jury trial in Orange County. My law clerk provided me with the script for judges who do criminal jury trials. There is a script. It runs, and if you do enough jury trials and you hear the judge, you know that you can tell pretty quickly whether the judge is reading from that script or not, and a lot of them do, at least to start with. You can learn that. You can learn how to do a jury trial. I think you can learn how to do a lot of things that you need to do, but I think sometimes we give too much emphasis on the well-qualified in terms of what the legal well-qualified means, as opposed to the broader picture of well-qualified in terms of temperament, well-qualified in terms of their ability to deal with self-represented litigants, well-qualified in terms of, I guess I said temperament. I mean, in terms of their willingness to work hard. So I just think that term, a lot depends on how you define it. I'll tell you one other thing. I know from Governor Cunin's book, as well as from conversations with Governor Cunin, that it came down to me and another attorney who had applied for this same position, who had a lot more experience than I do, and well-respected, and an attorney who I respect a great deal. And it came down between the two of us. And in her book, she says she chose me because I also had life experience. And I had life experience. I had been divorced. I had a child who I had co-parented with his father. All those things she took into consideration when she looked at well qualified. So, and I'm thankful that she did, because I love my job. But I can tell you, I probably would not have gone through. Plus, I didn't go to law school. I read for the bar law. It was just, there was a lot of things
Helpful, thank you.
So Tom and Barbara also have questions.
Judge, when you came into, in the nineties, I think you said, when you became a judge,
1990.
1990. So, and you were one of two women.
There were Superior Court judges. There were two district, back then we had district court judges and Superior Court judges. This was before the unification of the courts. So if you looked at district court and Superior Court judges and put them together, I would have been the fourth woman.
So, obviously a minority, like you said. So what was the key to getting more women? Was it, I'm sure there was enough women lawyers in the state to, to get the numbers up. Was it just a matter of getting the women to put their applications in? And how did that happen, I guess? Was there an effort to have women do that? And I'm wondering if it couldn't work the same way with people of color. Because I know we have people of color that are lawyers in the state. I don't know how many men, women, or people of color.
Right.
And is it a matter of kind of copying the same effort that was put into women?
I think you're right. I think two things happened. First of all, I think we did have more women lawyers coming into the state. And graduating from law schools. Law schools now, I sit on the board of the Vermont Law and Graduate School. I think the percentage of women now is 52 to 48. And that's, it has really, the profession has really changed a lot. So that was
reflective of population, right?
And keep in mind, then you have to have practice for 10 years. So you got to, so that helped. But to your point, yes, a lot of us back then went out and sought people, young women lawyers who, and said to them, have you considered, this is something you might want to do? And I think there were role models out there. I think, it was hard to get the first person in, but then there were role models. So, but getting that first one or two is like that's the hard one. I think.
What goes through my mind is you need to get the numbers in front of these folks.
Yeah. I in terms of the applications.
Right.
Yeah. Speaking of applications, I like the provision that allows a person to nominate another person. I just think that there needs to be something in there about if someone declines, if the person who's nominated declines the nomination, then that would stop the process. And I think that's the intent. The way it's written, it's just not really clear that the person who's nominated can say no and then not be. My final point would be both the provision that talks about courtroom experience and legal experience. One of the things and I think the Chief Justice spoke to this when he was here about the DEI Commission. And it goes back to your question about experience and what does well qualified mean? Certainly when I was the chief judge, we got, and some of them turned out to be great judges. I mean, no disrespect at all to the decisions that were made either by the nominating committee or but we've heard over and over again that names of practitioners who had mainly practiced in the family law area never got either never were on the list that was sent to the governor or because actually those people knew and some of us had really pushed them to apply because we thought they would be great. They had really good temperament. They were not on the list that they were not on the well-qualified list. And I don't know all the reasons for that. I just know that it happened a lot. And that one of the things that I was invited at one point to come and talk to the nominating committee. And I tried to stress for them what a big chunk of what a judge does is in the family court. it's probably 35 to 40% of the cases that a judge will hear over time. The civil cases it's much smaller than that. Only about 20, as would do the rotation schedule, only about 20% of the positions were going to be doing any civil. And there were only a few positions that would be doing all civil for the period of the rotation. Whereas family really needed that expertise. And one of the things that I think is important to understand is that judges train each other. Judges do trainings throughout the year, and then we have judicial college that happens every June. Occasionally during the 5 days of judicial college, we may have one or two outside presenters, maybe a judge from another state or somebody who has experience with, drugs or some other rehabilitation or some area. But for the most part, judges are training each other. And if you don't have a wide range of experience on the bench, with at least a certain number of the judges having deep experience in family, or if you deep experience in criminal or deep experience in civil, it's going to have a ripple effect in terms of the quality of education that the rest of the judges get. And so I think that is really important. And I wondered whether, some way to have the Judicial Nominating Committee get kind of an assessment from either the Chief Justice or the Supreme Court about looking at the roster, just a way, if you're on a board, for example, and you look at who do we need for new board members? Well, we really need we're really lacking somebody with really good financial expertise. We'll get somebody with financial expertise, or we're lacking somebody with legal expertise. If you had some assessment of, as you look at the current bench, what's missing? What do you need more of? I think that would be very helpful information for the nominating committee to get as it looks at the candidates and assesses qualifications.
So on that issue, looking at this a little bit closer, so I'm thinking that that doesn't really fit into whether somebody's well qualified. I think those are relatively objective standards that we have under subsection D. But just looking up what the language of the further language, if there's another place to fit this in, as far as something a little bit, I think we'd have to have this as something separate. Sorry, I'm kind of trying to find my way here as I'm looking at this, but
well, it did occur to me that in the courtroom experience section on page 6, it could say including experience either in civil, criminal, or family, that would then further define what you're talking about. Because there's a tendency to say, oh, if you've specialized in family law, then you're way too narrow to be a judge. But if you specialize in criminal law, oh yeah, you can learn the family and the civil, no problem. If you specialize in civil, you can learn the family and criminal, no problem. So it's never really made a lot of sense to me, given what the caseload is. But so that might be one place. In terms of input from the judiciary to the nominating committee, it probably would need I thought of that on my walk on the way over, and I didn't give much thought to where you could draft it in, but.
Right, we could talk with Eric, who's very good at that, to help
Yes,
figure that out. But it seems, yeah, that's a little bit, yeah, we could probably include it in courtroom experience, but it really would have to be tied to what the courtroom's needs are. And I see that as a little bit different.
Yes. No, I think that the two are two different things. Yeah.
So there's another provision that, thinking of adding, and getting input on, but it's not in this draft, and it's something suggested by the Office of Racial Equity, and we talked about last week. And that's adding, diversity of experience. And it kind of sounds like what was looked at by, the governor when you were appointed. The diversity of experience, a candidate shall have a broad range of lived experience, and candidates shall be drawn from diverse backgrounds. I don't know if that goes into the well qualified as opposed to here's something else you should be looking at when you are looking at folks who are well qualified. Or do you disagree? Do you think that that kind of, inquiry would fit into the determination of whether somebody's well qualified?
Where were they suggesting putting it in?
Well, it would into, adding it as one of the
Criteria?
criteria, the attributes of that a candidate shall possess.
Yeah,
Diversity of experience, but it sounded very similar to lived experience.
yes,
Yeah,
diversity
that's a,
experiences, yeah, it is very similar.
but I don't know if that goes into, maybe it does go into whether somebody's well qualified, or if it's just an additional factor to take a look at when you're determining of this list of well qualified candidates.
Yeah, it's always struck me, I mean, you have, if you go back onto page 5, you have legal knowledge and ability. Then you have courtroom experience, and then now we're adding legal experience. We've put a lot of weight on the law part of the experience and not so much weight on the other. So I think maybe making it,
So somebody could be well qualified. I mean, it could be a factor that's weighed in that they have a diverse background.
yeah.
It brings in the world diversity. Okay, so it probably can fit into this.
Yeah,
Okay.
it might, well, I think it might be its own thing, but I have to think about that a little bit more.
Okay, yeah.
I'll give it
I
a thought.
threw that out at you without warning, so.
It's all right, it's all right. Sort of like my dreaming up these things on the walk over here.
Barbara and Ken.
Thank you so much. This is very helpful. I have a few questions. So you mentioned when you applied, the criteria was having 5 years of experience.
Yeah.
Do you know when that changed and why that changed actually?
It changed when Phil Hoff was the chair of the Senate Judiciary Committee, I believe. That would have been back in the 90s. And I actually, I'm not trying to take too much credit for this. It's not what I would consider credit, but I think it might have been a reaction to my appointment. There were several civil litigators who just really believed that, civil jury trials were the be all and the end all of, experience. And I think that, it might have come out through the Bar Association, but I don't know. I mean, Bob may have better memory of that than I do.
And it is interesting because I think a family court is the most contentious of all the courts in terms of courtroom management. So it is interesting when you point out how, people view that. So you raised a really interesting point about people who don't know what they're getting into when they apply.
Mhm.
And I'm wondering if you think there should be something like an informational session that people are required to, I don't want to make more barriers, but in some ways, what I know from hiring people over my 40 years of hiring people is like you want people to be really clear on the job that they're applying for before you go to all the trouble and they go to all the trouble and it's not a good match. So I don't know if you have any thoughts about that.
Well, I think you make a good point that in hiring interviews, the candidate who's applying for the job often learns a lot about the job through the hiring interview. I mean, they do. They just, I think the people who are doing the hiring learn a lot about the candidate, but the candidate, because of the kinds of questions that are asked, learns a lot. And so one of the problems with the Judicial Nominating Committee is you don't have anybody on the nominating committee who has judicial experience. And so the job you don't tend to, you might not tend to ask the questions about that come from inside information about the job.
And that leads me to my next question. And this is, I think, not something we need in legislation or even in rule. But currently, we spend 30 to 45 minutes with each applicant, one time. I would never, in all of my experiences hiring, if I didn't do a second interview, have people talk, get input from, whoever, depending on what the job is. It just feels like it's such a little snapshot of information for a really important job that has, the potential to be there for many, many years. And I'm wondering, from both your experience as a candidate and serving on this, if you think the process should be more intensive or rigorous. Because even if the governor's office is doing that, it may be that 2 or 3 people would end up not being forwarded, that we would all agree for, whatever reason. And we'd be saving the governor time.
Yeah, I don't know. It's a hard one because you have your time constraints as well.
Sure. And
Your committee has its time constraints, so that
is different.
and you don't really want kind of a vetting committee first before you can, it's a hard one.
So you didn't speak to the timeframes, and I'm curious about that because a lot of states do have timeframes in place for each phase of the process. And we have talked about, like, if we're going to have one for a governor, we should have one for a nominating committee as well. And a few states actually have, if nobody's appointed by X, the chief justice will make the appointment, because belts and suspenders. And I mean, it's not about any particular governor. And I know you've served under a lot of governors. So I'd appreciate your wisdom on if you think adding time frames is a good or bad.
I really haven't, the one branch of government I have not served in is the executive branch.
Right.
And so I don't really know. I don't have a strong view about that. Most of the time, the decisions came pretty quickly. That the ones that were just, in my recollection, historically were, the appointments that had to do with the Supreme Court and justices on the
I
Supreme
wrote
Court.
on a piece of paper to take it downstairs last night, and then I got downstairs and
Mute Eileen.
don't see it here.
Eileen, you need to be, there you go. Sorry. Are you good?
I'm good. Thank you very much.
Okay.
So, hi again.
I
So, I know I've been around for at least 4 years on this. I know we see a lot of the same applications over and over. So backing up what my good friend over there, Barb said, we do get to see them numerous times. We only have a set pool to pick from, you might say. We will get some new people once in a while, which is refreshing. Every time I don't want to give out everything that we do, but we do our due diligence before we even start.
gotten phone calls.
A lot of phone calls, a lot of time, a lot of reading between the lines on the phone calls. But more so, all the questions and all the stuff that, you have such a diverse group of 11 that's already in there that have different backgrounds. They're the lawyers that are dealing with the judges that bring back valuable feedback of what we're looking for. And those of us that don't have judicial background behind us, you take that all into consideration. Consideration to go and follow up. And I'm not saying we're perfect. I mean, we can always do better and all that stuff, but
As I said, I have great respect for the choices that have been made, whether they're they're in part your choice and part the governor's choices. And I certainly had new judges come on who had pretty specialized experience, but were turn out to be great judges in areas that that they were not specialists in. So I'm not, I'm not even suggesting, I do think that at least when I was, the chief judge, my sense of the nominating committee, and Bob can correct me will correct me if I'm wrong. He has no problem with that. That the attorneys who tended to be appointed from the bar tended to be primarily civil litigators. So yes, they come from diverse places, geographically diverse backgrounds, but in terms of their specialty, there weren't many people on the nominating committee who were either family law practitioners and public defenders and prosecutors don't have the time. So you have to run for the office at the Bar Association. And so you have to be in a practice where you're able to spend the time, because it's a very time consuming job. So the process kind of gets skewed a little bit in terms of what the background is. But I think that can be compensated for. I certainly think it could become, a lot of job interviews now, people are given scenarios. How would you're doing a hearing in family court, and you have a defendant who wants to introduce evidence that violates the rule against hearsay. I'm that defendant. You explain to me why I can't introduce this piece of evidence that I think is so important. I think scenarios like that would be helpful to kind of getting a sense of what people's abilities were. And a lot of job interviews now are scenarios.
And I think we're using those, and I think, part of the questionings and looking for information that we may not already know. A lot of times we don't know, but we're digging for that stuff. And again, there's such a vast pool out there, and let's face it, most everybody knows everybody in this, in this,
True.
so, I don't know. I think there's such a diverse background, and everybody's got their own way of looking at things and dealing with it. I still think we handle it pretty darn well. I think it's a very important job. I think, and I can joke around on a lot of things in this establishment. But this is probably the biggest, most important job that I feel that I add to the state of Vermont, and I
Affects a lot of people's
take a
lives.
lot of pride in it.
Yeah.
So.
It affects a lot of people's lives, and I don't mean to be critical of
Oh, no, I'm not saying that at all. I'm just saying it
has huge impact.
is huge impact of this whole state. So, and I appreciate also your service too. I think you're fabulous.
Coach. Judge, how are you today?
Good. How are you?
Very good, thank you. This is kind of a general procedural question, because you set up my question that I shared with the chair around the scenario piece as an evaluative tool that almost every search or functional piece works towards now. And my question is more directed back to you and others who've served on judicial nominating. Do we actually do that? It's one thing to pick topics, to test experience. But sometimes I think, and the reason why this has been so valuable, that scenario basis, is that you see things you don't usually see. Because someone might know the answer to that question, but how do they perform the answer to the question? And that's what the scenario does. And so I'm kind of posing that as a general question to folks who've served, like on the, as we're looking at restructuring, kind of ensuring the next generation, because that's a powerful piece. We do a lot of hiring and at fairly high levels. And I found for us, those boards, that's been an incredible tool, because you can take all of the elements and evaluate all the elements. But then when you put it into a practice piece, that's where the rubber hits the road, so to speak.
Yeah, I think that's the hard part. I mean, one deficit, if you will, that comes from the structure itself is that you have no judges on the nominating committee, retired judges or, a sitting judge would have a hard time actually because they're busy. Same problem that prosecutors have. But you could do it with a retired judge, and I am not volunteering for that job. I just want to be really clear. But you have enough retired judges that you could use that at least you'd have somebody on the board who had that expertise. But if that weren't the case, you could also the nominating committee could easily reach out to judges and say, if you wanted us to ask a scenario type question to candidates, give us a question. And you might get some really interesting and rich results from that. So it's a couple possibilities.
So I have two other questions, and these are questions the other witnesses I'd like them to weigh in, certainly. I don't know if you didn't weigh in on the change of 10 years of practice, this not having to be in Vermont. If you have any comment on that.
I think that's a good change. I don't know, I don't know why. I mean, especially since there's another provision that says that you're going to look at their Vermont experience. I don't know why. Yes, there's some variation state to state in terms of the law, but again, you're going to have to learn a whole lot. So I'm not sure that that's a huge thing.
So the other is more specific, and it has to do with rules of evidence. That says subdivision B9, candidate shall have sufficient trial or other comparable experience that ensures knowledge of the Vermont rules of evidence and courtroom procedure. Why does it have to? I mean, the rules of evidence are pretty standard. I mean, I can understand courtroom procedure being different in Vermont relative to other states, but is there really that much difference in rules of evidence that we can't? If you have 10 years of experience and 7 years are trying something in Connecticut or whatever.
Well, I thought that 9 was applicable regardless of whether, I see. Yes, I think you could strike Vermont. I think you could strike Vermont and just put rules of evidence.
Right.
Because they are very similar from one state to the next.
But I think it probably should say, and Vermont courtroom procedure though, because that isn't necessarily similar. So I would just move Vermont as, I know
that makes sense.
No, that makes sense to me.
I appreciate it. All right. Any other questions for Judge Davenport? And we'll bring on David Silver next to weigh in on this bill as well, if you're available. Thank you for being here remotely, David. I appreciate it. And if you could identify yourself for the record and let us know what you think of the different aspects of this bill. And you may have heard earlier that you don't have to say a whole lot about the residents, getting rid of the residence requirement, because that's pretty much at this point out from all the other testimony we've received. So over to you.
Yeah, I did hear that. I want to say hi to my colleagues, my former colleagues, Barb and Ken, and I think I saw Maxine back there, and Dave Mickenberg. He was on the Judicial Nominating Board with me a while back. I miss you guys. I know you missed me.
Yeah. We channel you all the time.
I was thinking that.
So my name's David Silver. I'm a partner at Barr Sternberg here in Bennington. I've been a trial attorney for 40 years, and just saying that makes me feel old. But mostly my practice has been criminal defense. I was a public defender for 9 years, both in the New York State in the Bronx, and then a federal defender in the Southern District of New York. And I came up here in 1990 as a public defender, hired by Dave Howard, who we worked together, who became a judge later on. Since '92, I've been a partner at Bar Sternberg, and my practice has been primarily criminal defense in state and federal courts, but also a significant part of my practice, and probably it's up to 50% now, is civil work. I do mostly plaintiff's personal injury, although I just had 6-year class action suit along with Emily Justices and other lawyers representing the community here in the toxic tort PFOA matter against St. Cobain. So that's my basic experience. I was on the Judicial Nominating Board, the state one, for 6 years in the prior term. So I guess I've been off it since I think it's been a year or two. And I've just finished being on the federal judicial nominating panel. I want to say hi to Bob Paolini, also was very helpful in that whole process. And I was on the 2 prior federal judicial nominating commissions that Senator Leahy, when he was senator, and organized. So that being said, I guess there are a couple things I'd like to say. First of all, and I was talking about 601B1 and 602A2, talking about making it 12 members and requiring a supermajority, that is 8 people. I think those 2 provisions obviously should be discussed together, and I'm strongly in favor of that. I think the goal is to provide the governor with candidates that are going to be excellent judges. I know we use the term well qualified. It's a highly subjective term, and I don't think, no matter how you try to define it, it's really a subjective term. But I think we can all agree that we want the best judges we can get to sit in Vermont. And since it's obviously a subjective determination, and because the position is so important, I totally agree with Judge Davenport that it's really imperative that the candidates, their qualifications so compelling that it convinces most of the people on the panel. In my experience, I was on the board for 6 years, and we sent up a lot of candidates who were unanimously voted for, or it might have been 10-1 or 9-2. But we also sent up candidates that were 6-5, and often that was the candidate the governor picked. And I don't think we want mediocre so-so judges, and I think he picked some, in my not so humble opinion. So I think it's unfortunate for the quality of the bench to have someone who barely passes muster. I think you want I think the supermajority is pretty important. And just as a background aside, just to respond to some things that Judge Davenport said, I think we need more lawyers on the panel, not fewer. I think the lawyers' knowledge about not only their knowledge about the candidates themselves, because we have a relatively small legal community, but also their ability to reach out to other participants in the community to get important reference checks. But the reference checks that the candidates give us are uniformly glowing, and it's almost useless. It's not useless, but it doesn't help us very much, because everybody says that these are the best people since, Oliver Wendell Holmes. So so if we were going to just go by the candidates' reference checks, we'd vote everybody up. So we really need to hear from people they don't refer to, and having lawyers on the panel to do that is important. And also, the lawyers, the ability for a candidate to express cogently complicated legal issues, to be able to explain legal issues so that a layperson can understand it, and to write and research effectively and write in a way that's understandable. It really takes the lawyers to review those legal writings and talk to the non-lawyers on the committee about it. That happened all the time. Generally, it was Ellis Spotswood who did it, but I mean, without lawyers on there to review and evaluate their legal skills, really it just becomes almost like a personality contest, which is important. I agree with Judge Davenport that temperament's important, but also legal acumen, legal skill, and the ability to communicate effectively with laymen is really important. So I think the lawyers are important to do that. I don't know how you do that with 12 people, especially if you're going to have a diversity equity person, but maybe you might suggest that that if available, the House and the Senate should have at least one lawyer each, if available. You know, I mean, I think that makes sense. Anyway, I would like to talk about the governor must pick from the list. I think that's a very important provision here. I don't know if any of you remember this, but there was a big brouhaha back when I was on the board when the governor rejected our list and asked us to pick, send him up another list. There was also a claim that list, that he wanted that because we didn't send him up diverse candidates. Well, we had sent him up diverse candidates. We sent him up women, and we sent him up a woman of color, and he just didn't like them. I think there's a really important separation of powers situation here, because the legislature has created this law that requires that requires this. It talks about how this committee or board is picked, and requires the governor to pick from this list. And it seems to me that it's presumably the rationale for that is presumably to limit the discretion of the governor, so he can't just pick anybody he wants. But if the governor can just keep on rejecting lists till he gets somebody he wants, that undermines the independence of the legislature, and it undermines the ability of the panel to limit reasonably the discretion of the governor. But on the other hand, I don't agree that the governor, that if the board sends up just one or two people, that really limits the governor's discretion. So I think on balance, you know, because you don't want the committee to send up one person, say, Governor, you got to pick that person, because that undermines the governor's right to choose and exercise his discretion or her discretion. So I think a compromise there would be if the board sends up less than 3 candidates, the governor should be permitted to require another list. But there are times when, and there were times when I was on the board, that there weren't more than 3 candidates that were well qualified, and that wasn't the board's fault. That was just the quality of the candidates. So if we sent up, you know, and it may be a time where you just don't have more than 2 well-qualified candidates, and the governor should be allowed to say, okay, I looked at these 2, I don't want them, I want another list, and I think that's reasonable. But for the governor to, you know, we send up 6 people and the governor says, we don't like it, I want another list, I think that's wrong, and I think it violates the separation of powers.
Before you go on, there's a question from Ken.
Hi, Dave. So in all your length of time, how many times did that happen with different, I think you served what, with the 6 years under 2 governors, or no?
I think maybe, I don't remember it. I think it was towards the end of Governor Shumlin, and then it was most 4 years of Phil Scott, I think.
Okay. So how many times did that happen?
I think it happened once with the Supreme Court, and then once that happened right when I was coming on the board, though, so I wasn't part of that when Governor Shumlin. So I withdraw that. I think it just happened once with Governor Scott.
Okay, thank you.
The other thing, unless there's any more questions, I just wanted to move to the next thing that I had a comment on. I'm glad you got rid of the residency requirement. I think, you know, I first of all have a great deal of respect and admiration for Judge Davenport, and I think you know, and we miss her on the bench, but I think that, you know, 10 years of experience is a bare minimum. And I think you can find people that have 5 years of experience that would be much better judges than someone with 10 years or more. And you can find people with, you know, 10 years of experience that'll be a lot better than people with, you know, 5 years or 6 years. But you got to set up a policy, and you got to look at the percentages, right? Because you're going to find exceptions to every policy, you know. And I respectfully submit that Judge Davenport is probably an exception. You know, I think 10 years is you're still a young lawyer. I run a business. I have associates working for me that have been here for 13 years, and I wouldn't want them on the bench. You know, they're still learning, you know. And not only is it important to have at least 10 years of practice, I think you should have, I think it all should be in Vermont, but I think it should be at least 5 years in Vermont, because, you know, it's not only important for you to know what the Vermont legal community is, but also what the community standards are, what the community values are. And it's important for the legal community to get to know you so that they can have valuable input. And I don't think 3 years is enough. You know, you can say you're licensed to practice, you know, for 3 years and never set foot in Vermont. You know, you could be just doing corporate stuff and never even go to court, never been anything. But so anyway, I think, you know, I think 5 years is a bare minimum. I think 10 years of experience is a bare minimum. You know, I understand that we want more people to apply, but, you know, not at the expense of quality. I don't think that's I don't think that's a price you should pay. You
Before you
know,
move- I'm sorry, Barbara has a question.
So David, I'm wondering about the description you had of why people should have a lot of Vermont experience. If we're looking to be a diverse and welcoming community, wouldn't we want people to not just be sort of coming in and replicating what is, but also bringing in new ideas and possibilities? Because it seems like as a state, at times we could be very inward and think, we're Vermont, we do it this way. And a lot of times that's awesome. But other times it's like, we're Vermont, we do it this way. And look at this cool thing that they're doing in Oregon. Maybe we should give some thought to adding that into the mix. And I know that you and I are both Flatlanders from New Jersey, and I wouldn't want us to be sending out the message that you have to be sixth generation to apply. You know what I mean? And I know you're not saying that, but being more sort of open to ways and experiences that people can bring.
well, I actually don't have I mean, I don't think what I'm saying is inconsistent with you saying. Requiring 10 years of experience doesn't mean you're saying that people with new ideas or different backgrounds or from different areas shouldn't apply. I don't have a problem with giving the board some discretion in making exceptions, because I do think that makes some sense. I think there should be some rules about that. Again, I think it should be a super majority vote to make an exception to the rule. I don't think that's a problem. You know, I know that.
What about the years in Vermont experience, like the requirement for how many years in Vermont?
I think at least 5. I think 3 years. I mean, think about that. I mean, that someone who came here in 2020 could apply for a judgeship now. I don't know. And to me, that seems like a blink of an eye to me. Maybe just because I'm so old, but I think that I think that that's not the problem with getting more people on or diverse people on the bench. What's the problem is getting them to apply. You know, that's the issue. And the other problem is we don't have a diverse legal community. We just don't. You know, the numbers aren't there. But you know, I know that when I was on the board, both under the able leadership of John Evers and the able leadership of Ellis Spotswood, we were really concerned with trying to get more people from different backgrounds on the bench. That was one of our values, and that's one of Vermont's values, I think, and it's one that I think was shared by everybody on the board. It wasn't that we didn't want to pick them, that they weren't applying. And I believe in diversity. I want more people with who have backgrounds dealing with the underprivileged that are traditionally discriminated against, people of color and different ethnicities. I want people who are judges who have dealt with them. All my career, I've been representing the underdog, and I want someone who's compassionate and has sensitivity about that. But I don't want a person on the bench that isn't going to be a good judge just because they're from a diverse background. If I had two people who were applying and they seemed like equally qualified, but one was from a traditionally underprivileged ethnicity or group, I would certainly want to pick the person who was from that traditionally underprivileged group, because I think that's really important. But I think if you pick somebody just because they're diverse and they end up being a crappy judge, that doesn't do anybody any good, and in fact might have the exact opposite effect that you want by reinforcing negative stereotypes. So, I think it's a very tricky issue. I get it; it's a sensitive issue, but I think lowering your standards to get more people on the bench is the wrong way to do it.
So just real quickly as well, I mean, we've tried to balance that easing of the applicant process by having the additional consideration for the attributes of the candidates of legal experience in Vermont. So if you are a person who only has 3 years of legal experience, you still have to get over the bar of the consideration of what your ties to the Vermont legal community are, the nature of your practice in Vermont, and the familiarity with the Vermont's legal system. So we're trying to open up the applicant pool a little bit, have fewer barriers there, but make sure that this is an issue that's taken into account by the board when they're evaluating candidates. I don't know if you have a comment on that scheme that we're trying to set up here for this, but.
Yeah, I'd say two things to that. One, I'd be interested if you had any data that supports the conclusion that by doing that, you're going to get more diverse candidates.
But since we haven't done it, we haven't been able to gather data since we haven't actually done that. So
I mean, you can look at the bar and see how many people have only 3 years experience and how many of them are from diverse backgrounds, I guess. But again, I don't have a problem with giving discretion to the board to make exceptions to the rule. But I think having a 5-year requirement, I mean, to say, the 5-year requirement is basically one that is there so that you do have familiarity with the various parts of the judicial system, not just some familiarity, but a profound familiarity. And you could establish that. If you can establish that as a person who's only practiced here for 3 years, to the satisfaction of the board, I think that's fine, but I think it's unlikely that you could, but I think it's fine. I'm not sure it's a huge thing, because I think that, having been on the board, I think that they're going to be able to make the determination as to what, regardless of what you say in your application, there's going to be reference checks and stuff like that. But I mean, one of the problems with having someone with such little experience is that the rest of the legal community don't get a chance to really know you in any significant way. So it makes it harder to do, I think, effective background checks as well. And I think that's something to think about.
All right, appreciate it. Ella, did you have a question? No, I thought I saw your hand.
No.
You're good. Karen, go ahead, Karen.
Yeah, I guess I'm just trying to fully understand this, because I'm seeing that if we open the door to nominating, that's a positive thing. I'm not nominating, to applying for this or getting to the committee. But then I feel like there is a part of creating this criteria and trusting the committee to do the work of, is this person qualified to move to the step of being on the list to go to the governor? So there's part of me that wants to open it up and open the door to allow more people to go, and then trust the committee to do that work. And I'm hearing that there could be a downside to that from your perspective of allowing more names or more people to go through that first door. Is that correct?
Well, I mean, the downside is what I think I just described. I mean, I think that, as Barbara said, you've got a pretty small snapshot of a person in a 45-minute interview or whatever it is. And sometimes what happens is that your picking someone as a judge because they interview well, and the only thing that balances against that is the amount of information you gather from the reference checks, the numerous phone calls and interviews that we do with with people that weren't, that were not part of the candidates' references. And to me, you have someone with 3 years of experience, say, 3 years at the Attorney General's office or something, there's not going to be that many people that can speak to that person's qualifications other than the people that work with that person. And they're going to have a pretty clear bias. So not always, but and that can be very useful. I think that's the main downside, is there's not going to be that much information or track record that from which to judge them. Again, I think it's okay for the board to make exceptions. But I think that it should be presumptive, at least, that you have 5 years of experience and 10 years of practicing law. I think, you're a baby lawyer at 10 years. You really are. And I think you really need more time. We want experienced judges. And if I could just move on to one other thing that you guys were talking about, it's a really hard job, as Judge Davenport says, and it's really kind of it's really dramatically under-resourced. But I really believe that judges in Vermont should specialize, not necessarily between civil and criminal, but I think family law, there should be, I think family law judges should be family law judges, and you should pick them for that. There's very specific skill set that you need as a family law judge that doesn't translate into civil or criminal. The way you speak to children, the way you speak to litigants, the way you speak to pro se litigants, the level of patience that you have. And there's different law. In fact, there's very little law in family law. You could be highly qualified to be a family law lawyer, but really not, family law judge, but really not qualified to be a civil or criminal judge. And I'm afraid we have that. I've seen that many times. I know plenty of judges who I love to see in family court and I hate to see in criminal court. They're out of their depth, and I think if you talk to family law practitioners, you'll find that there really should be lawyers that specialize in family law. That the judges that specialize in family law. I think civil and criminal, you can go back and forth. I really do. I think there's very similar skill sets, and the learning curve is not too steep. Anyway, that's my 2 cents on that.
All right. Any other questions for Mr. Silver? I think we're satisfied. We really appreciate your perspective, and so we're going to take a break until 10:30, and then we'll go to Maxie. Are you okay with timing on that as well?